The leak of a draft U.S. Supreme Court opinion has shocked the legal community. Factor in the subject matter, abortion, and the issue attracts even more attention. Beyond the headlines, there is a critical issue. How could a leaked draft opinion affect the operations of the nation's highest court moving forward? Joining us now with some insights is Mark Martin. He is the Dean of the Regent University School of Law and the former Chief Justice of the North Carolina Supreme Court. Thanks for joining us.
Oh, absolutely, Mitch.
First of all, your initial reaction when you heard that this draft opinion from the U.S. Supreme Court had been leaked?
I was shocked, as I think virtually every American was, and particularly those who work in the legal system and understand the nature of how appellate institutions function.
What kind of potential impact do you think something like this could have?
Well, you first have to understand that this norm of confidentiality arises from the judicial process itself and goes to the fairness and legitimacy of the judicial process. And so it goes right to the heart of the adversarial system of justice.
I wanted to ask you, because you have been involved in this process yourself as a justice and then later the Chief Justice of the Supreme Court. You've had to deal with this sort of confidentiality. A case is decided, but opinions are going back and forth. How important is it that all of this remains within the court and initial ideas aren't thrown out there in the public for the political process to start playing a role?
Well, this is the key question. And I think it's very helpful for citizens to understand why we have this rule to begin with. This rule developed over time because it was so important for the court to have a process where you have integrity of process. Let's talk about a couple hypotheticals. Just imagine if you have a case before an appellate court, you have a draft opinion, such as in this instance that is leaked by someone at the court. And so as a litigant, as a party, you think you've won the case. Okay, so you see this draft and you assume that this draft is going to be the final outcome. Just imagine how fundamentally unfair it would be to a party before that court to perceive it wins, only to learn in the final outcome that you in fact have lost. But it even goes beyond outcome. The whole reason that cases are on appeal oftentimes is because you have complex areas of the law, and oftentimes an issue on appeal can be a point that has not yet been conclusively resolved in that jurisdiction. So resolving a complex appeal is tricky, and it takes a lot of collaboration. That is, in fact, why we have more than one judge. We want to get the full breadth of life experiences. Lawyers have different concentrations and areas of the law. And we're hoping that this composite of a multi-member court, that you'll have the institutional competence, judgment, and yes, wisdom to resolve that issue in a way that is not only fair to the parties, but also works well for the legal landscape and for the society at large. And so when you have reasoning that is thrown out prematurely, that can be destructive in several ways. First of all, when you have an internal circulation, the author in justice is saying, look, I've listened to everyone's input. We've taken a preliminary vote. Now let's try to reduce this to writing, because we oftentimes can miss a critical point of the reasoning. Oftentimes appellate opinions change appreciably so during the internal deliberation and review process. And as I've already mentioned, oftentimes the court can even reverse the vote. And I had that happen when I was on the NC Supreme Court. I personally authored an opinion. It was 4-3, and the fourth vote disappeared. So the opinion actually went out another way. Now, ethically, I'm obviously not going to talk about which case that was, but the point is the internal process worked. The party that would have won and didn't never knew that. So there was no destructive impact on the court procedure itself.
You never had to go through this process of having to deal with a draft opinion circulated and then trying to cope with what that meant. But what is your sense of how something like this could affect the trust among the justices and their clerks and staff members and even their collegiality? I can't imagine this is a good thing.
No, you're absolutely right. Trust will be the first casualty in this situation, as well as collegiality. Because remember the reasons we've enumerated, we're trusting each other to do the best we can. Courts play a critical function in our society. It's the gold standard for the world, the American justice system. Though imperfect, it's the gold standard. And if you start taking away critical ingredients that go to that success, such as leaking interim work product, you totally take away the trust among equal members of an appellate court. Keep in mind that everybody has one vote, even the Chief Justice, and that's true on every appellate court. So everybody is working as an equal, they're trusting each other. You are showing your draft work, you're asking for help, you're trying to make sure the court itself, ultimately it's an opinion of the court as an institution. And in most instances, unless you have a per curiam opinion, there is a name on the opinion, because when the justice and his or her staff are working on that opinion, it takes weeks of labor, painstaking legal research, reviewing the record, reviewing the transcript. We are fallible human beings, and that is true for judges. And you are asking the other chambers to help double check the accuracy of the procedural history, the facts, the legal reasoning, the legal citations, and I'm just getting started. So when that goes out prematurely, you are putting at risk the judicial process itself, and clearly trust that litigants, lawyers place in an institution. And so that's the external stakeholders, but as you alluded to it, you also have the internal stakeholders. Once the relationship of trust and collegiality is broken, it's very hard to rebuild.
Can you think of anything that the court can do to assure that something like this doesn't happen again? It seems to me that one of the bad signs is, now that it's happened once, what stops it from happening again?
I think you have raised a very important question. I was so pleased to see that earlier today that Chief Justice Roberts has launched an investigation with the Marshal Service, which of course would have access to the full array of resources in the federal government. I think we have to get to the bottom of it, because think about it. You have judges who are equals, but you also have law clerk and you have court staff. There has to be a strong deterrent to this happening again. In an America that is so divided on so many culture wars issues before state Supreme Courts, federal circuit courts, and in fact, the United States Supreme Court, you've got to make sure that staff know this is totally unacceptable, will not be tolerated, as well as from the law clerks and the judges themselves.
Final question for you. You've been watching action on the U.S. Supreme Court for a number of years. You've taken part in similar types of debates and deliberations as a justice and Chief Justice of the North Carolina Supreme Court. Just how bad a day is this for our U.S. Supreme Court and the American judicial system in general to have something like this happen?
Well, it is a bad day, and it's a bad day if this were to happen in any case. But when something like this happens in a high-profile case such as this, it just really casts a very damaging shadow on the institution itself. But, you know, we cannot always guard against this type of thing from happening. I think the real key is, how does the court now respond as an institution? And I'm very encouraged by the action that's been taken by Chief Justice Roberts today.
Mark Martin is the Dean of the Regent University School of Law. He is the former Chief Justice of the North Carolina Supreme Court. Thanks so much for joining us.
Thank you, Mitch.